Hello viewers, good afternoon to all of you and welcome who are already there and will be coming soon. Today I again have with me Qazi Imran Iqbal Sahab and we will be discussing as usual immigration updates. We will take your questions and the questions we have over the emails we'll try to respond here, and the messages we have received so far we'll try to respond those as well. Also we will discuss some matters in relation to family law. Some information we will try to give you there. So first of all, Imran Sahab, we start with this new judgment which came end of May regarding the recourse to public funds. All of you know that people who have limited leave to remain in the UK under 10-year category, they normally get visa and it says that no recourse to public funds. So that has been changed even before the judgment came. If you remember, I'm on record, my YouTube videos are there, that all those people who are suffering, they are destitute, they should make an application to the Home Office. But now there is already a court order. So if you are in that situation, you can apply, and I would invite Imran Sahab to explain a little more. And Imran Sahab, if you can do that in Urdu, because so many questions I have got from people who wants to get the answer in Urdu. So if you can start on that.
Sure sir, thank you very much. Thank you viewers. Basically sir, ये और जो हमारे viewers हैं उनके लिए भी कि एक ये काफ़ी इशू था वाइडली स्प्रेड के जो लिमिटेड लीव टू रिमांड वाले फैमिलीज हैं या स्पाउसेज हैं उनको नॉर्मली कंडीशन होती थी नो रिकोर्स टू पब्लिक फंड अपेंडिक्स FM और अपेंडिक्स EFM में। तो प्रॉब्लम काफ़ी उसमें लोगों को जो 10 साल बाद उनकी इंडेफिनेट ड्यू है, जो 4 एक्सटेंशन हैं, एक तो होम ऑफिस की हैवी फीसेस और उसके अलावा इमिग्रेशन हेल्थ सरचार्ज एकदम जो उन्होंने बढ़ा दिया था कुछ साल पहले। तो कंसिडरेशन दैट लोग उसको काफ़ी प्रॉब्लम में और काफ़ी सफरिंग में इमिग्रेंट्स रहे हैं। तो एंड पे आखिर एक फैमिली है जिन्होंने हिम्मत की है वाया देयर लिटिगेशन फ्रेंड एंड दे चैलेंज द डिसीजन इन द हाई कोर्ट। तो लॉर्ड जस्टिस बीन और जस्टिस चैम्बरलेन ने एक जजमेंट पास की है जो डिटेल जजमेंट आई है 21 मई 2020 को रिसेंटली। तो उसमें उन्होंने क्लियरली कहा है जी कि these conditions are contrary to Article 3 of ECHR कि जो families हैं उनके लिए right to life is really difficult under these circumstances, especially expensive city है, expensive country है, तो उनके लिए जो living conditions हैं वो बहुत मुश्किल है उनके लिए fulfill करना, especially with the children। तो उस पे ये WA child with the help of litigation friend versus Secretary of State केस हुआ है, जो कि एक बड़ी अच्छी और गुड न्यूज़ है इमिग्रेंट्स के लिए जो लोग लिमिटेड लीव पे रिमेन हैं और जिनको जस्टिट्यूशन की इशू है या जो जस्टिट्यूट होने के करीब हैं, वो लोग जो हैं वो फौरी तौर पे चेंज ऑफ, अगर जिनको ऑलरेडी वीज़ा इशू हुआ है तो वो चेंज ऑफ कंडीशन की एप्लीकेशन करेंगे और जिनको नहीं हुआ वो इनिशियल एप्लीकेशन में ही इसको जो है वो एलिब्रेट कर सकते हैं और इस जजमेंट से वो फ़ायदा उठा सकते हैं, क्योंकि ये हाई कोर्ट का केस है और अभी तक गुमानजी या लिटिगेशन डिपार्टमेंट इसको फर्दर चैलेंज नहीं किया।
So this is the answer from Qazi Imran Sahab, that all those people who have been granted leave already under 10 years category with no recourse to public funds, they can change their status conditions to recourse to public funds. उसके लिए एक simple सा form है, there is no home office fee on that. You just need to say that you are out of job, you are destitute, you are relying on family and friends, and that help is not there anymore, and you can get it changed. And if you're making a new application, still you can add that. And you should already know that those people who cannot afford the application fee of Home Office, which is say per application £2,053, you can always apply for exemption of fee anyway. So this is useful information. Just before start of the this Facebook session, I had a call on my mobile and the gentleman was asking the same question, and I said please do watch our Facebook live and we will try to answer that. Welcome all of you who have joined us on Facebook. So please let us have your questions if you have any, so we can answer those. Uh, there's another extension of deadline, as we have already informed our clients and viewers that all the visitors who have come here in the UK, and either if they were on multiple visas and their entry was expiring after 24th of January but before 31st of July, or those who were on 6 months visa and again their visa expired before after 24th of January and expiring before 31st of July, they just have to send a simple email to Home Office and their visa will be, or entry will be, extended until 31st of July. All those people who have done this before 31st of May, because the initial deadline was 31st of May, they don't have to send it again. But all those who haven't sent it, or their visa was expiring after 31st of May and they need to send now. The other flexibility is, even though this flexibility is clashing with the existing immigration rules, but Home Office very clearly stated that due to pandemic situation, all those visitors who wishes to switch whilst in the UK to student visa or work permit visa or entrepreneur visa or startup visas or spouse visas application, they can do so, provided they say that actively we did try to go back, but because of the pandemic situation, or they were isolated, or they were advised to do so, they cannot go back for the time being, or they cannot go back before 31st of July. They are allowed to switch whilst they are in UK. So this is very, very important flexibility announcement by the Home Office, and still not many people are understanding that. They still don't know what it means. It means as a visitor, you can switch your application before 31st of July, which was not allowed in normal circumstances, and which will not be allowed after 31st of July unless the Home Office extend this deadline. So Kaisab, I also wanted to discuss a little bit on family matters. Home Office statistics suggests that due to this pandemic situation, there are so many domestic violence cases between partners, between husband and wives, parents and children. So there are so many issues on those. So if that is the case, you can always go to your legal representative, your solicitors, and you can get advice, and accordingly you take the remedy. But there are different organizations who can do that for you free of charge. If you are in need of any protection order, if you are in need of any other injunction, prohibitory steps and all that, you can get help from these organizations. Home Office has extended their funding to these organizations. So there's another matter going on because we are getting so many cases in relation to contact orders or custody orders with children, and people want to understand. They do not understand there's a difference between custody order or residence order, and there's another order called contact order. So contact order is an order where children will stay with, say, mother, and father will have to apply to the court. It's a permission that I should be able to see my children. If the other partner, if the mother is not going to allow you, so this is the only way. If she allows you, that's fine, that's your private arrangement. Otherwise, you have to go to the family court and apply for contact order. There's a department called CAFCAS. They will come, they will assess the situation, they will interview the children, they will interview you, your spouse, and they will make a recommendation. That is very strong recommendation. Courts usually give very much importance to CAFCAS report. So it is important that you give them full and frank disclosure. So if there is a situation, and it helps you with your immigration status as well. So if, for an example, you were on spouse visa and for some reasons you are not with your partner anymore, your visa is still valid, you can go ahead, and if you have a contact order or you have contact with the children, you can prove that you can switch your visa from partner to parent route, and whatever time you have spent in partner route will be considered under parent route. So it will remain 5 years. You will not go into 10 years category unless you did not make the application in time, you became an overstay, and then they will put you back in 10 years category. So that is important. The other issue which we are facing here now is those people who are becoming victim of domestic violence. All those people who are on spouse visa, they came from abroad, or they were here and they got visa under partner route, under FLRM category. If there is an abuse of domestic violence, again you can make an application directly to the Home Office, and this application will be for indefinite leave to remain, even you have not spent 5 years in this country as a spouse. The requirement is you have to spend some time with your spouse in UK in that category, and if you can prove that you were a victim of domestic violence, you can apply for indefinite leave to remain. The major requirements are either you have a police report, case reference number, crime reference number against the other partner, or he or she has been charged. You have an injunction, and it's not an interim temporary remedy, and not ex parte order. Ex parte means one-sided order. And then you have some medical proof from your GP that yes, you did inform the GP that you are a victim of domestic violence. And keep this in your mind that domestic violence does not have to be physical. It can be mental torture. There are so many men who are complaining that they were victim of domestic violence, not physically, but they were tortured mentally. They were tortured financially. So there are so many cases coming up. So as we were discussing before in this matter that
yes,
the cases are on high.
Yes sir, cases are on high and the Home Office is well aware of the situation. अभी होम ऑफिस जो है वो काफ़ी सीरियसली उन्होंने इन मैटर्स को लिया है, स्पेशली हमारे जो वहाँ से मर्द स्पाउसेज आते हैं, जो जेंट्स आते हैं, उनके साथ जहाँ पे ज़्यादा ज्यादती होती है, और वो चूँकि एक एशियन कल्चर है कि वो मर्द हैं और वो सफ़र कर रहे हैं, तो होम ऑफिस ने एक इस पे एक लोगो और एक स्लोगन भी हम कह सकते हैं, जस्ट टू बक अप के जी आप सामने आए और अपने आप को डोंट सफ़र इन साइलेंस, स्पीक आउट। तो इस जैसे आपने पहले भी इस पे रोशनी डाली है, एलोबरेट किया है जी कि इन्होंने अभी काफ़ी सारी जो फंडिंग है वो काफ़ी सारी ऑर्गेनाइजेशन है, जिनमें से मेनली हेस्टा है और माइग्रेंट हेल्प है, जो होम ऑफिस ने फंडिंग अपनी किया और उनको ट्रेन भी किया है ज़्यादा उनके जो सोशल वर्कर्स हैं कि जी ये जो सिचुएशन है इसको किस तरह हैंडल किया जाए। तो इसलिए दोबारा गुजारिश है, लास्ट प्रोग्राम में भी हमने की थी इस पे बात, और आज भी आपने एलोबरेट किया है कि अगर कोई बंदा सफ़र कर रहा है और वो ज़रूरी नहीं कि उसको कोई फिजिकली मार रहे हैं या पीट रहे हैं या फिजिकल अब्यूज़ कर रहे हैं, उसको वो मेंटली भी, कई लोगों से ऐसे भी मुशाहिदे में आया, आपके भी मेरे भी और हमारे पास ऐसे केसेस भी आए हैं कि लोगों को जो वेजेस है वो काम करके आते हैं और उनसे वेजेस ले ली जाती है, उन बेचारों के पास इतना नहीं बचता कि वो बैक होम कॉल करें, कॉन्टैक्ट करें। तो इस चीज़ को होम ऑफिस के पास भी ये इन्फॉर्मेशन ऑब्वियसली लॉयर्स के थ्रू गई हैं मुख्तलिफ, तो अब इस चीज़ को उन्होंने काफ़ी सीरियस लिया, और अगर इस तरह की कोई सिचुएशन है, कोई भाई कोई भी सफ़र कर रहा है, तो ही शुड कम फॉरवर्ड। और इतना सीरियस होम ऑफिस ने लिया कि इसको उन्होंने मॉडर्न स्लेवरी में एक कैटेगरी में कंसिडर कर लिया कि दिस इज मॉडर्न स्लेवरी। यस जी हाँ, तो वो मॉडर्न स्लेवरी में इसको उन्होंने ले लिया जी कि अगर आप एक बंदे को इंडिपेंडेंटली लाते हैं स्पाउस वीजे पे, खातून है या जेंट है, और यहाँ पे आके वो जो एक्सपेक्टेशन लेके आता है वो नहीं है, और आप उससे औरत है, घर का काम भी करवाते हैं उसकी मर्जी के बगैर, उसकी इनकम भी आप ले लेते हैं, और उसके अलावा उस पर टॉर्चर शुरू हो जाता है, तो दे आर टेकिंग इट एज अ मॉडर्न स्लेवरी। तो ये बंदा या औरत सब्जेक्ट टू मॉडर्न स्लेवरी है। तो इस पे अगर कोई सफ़र कर रहा है तो डोंट सफ़र इन साइलेंस, कम आउट, सी एनी लॉयर, और डायरेक्टली होम ऑफिस की इस पे हेल्पलाइंस भी हैं, जो गूगल करें तो वो भी मिल सकती हैं, डायरेक्टली भी कांटेक्ट किया जा सकता है, लॉयर्स के थ्रू भी कांटेक्ट किया जा सकता है।
बहुत शुक्रिया इमरान साहब। So we have a question from Babar Sahab. Welcome Babar Sahab. Your question is, what about people who are on multiple visitor visas in the UK? Their flight cancelled due to no airline. Can they stay over 6 months in one go? बिल्कुल यही मैंने एक्सप्लेन किया है अभी थोड़ी देर पहले कि अगर आप विजिटर हैं इस मुल्क में, आपका वीज़ा या एंट्री ख़त्म हो रही थी 24 जनवरी 2020 के बाद और 31 जुलाई से पहले ख़त्म हो रही है, तो आप एक गो में 6 मंथ से ज़्यादा रह सकते हैं अनटिल आप वापस चले जाते हैं। तो ये 6 मंथ से ज़्यादा जो आप रहेंगे, ये इमिग्रेशन रूल्स को आप ब्रीच नहीं करेंगे, यही मैं बताना चाह रहा हूँ। तो अगर फ़्लाइट कैंसिल आपकी हो गई थी तो आपके इख्तियार में नहीं है, और आप यू आर कीप ट्राइंग टू गेट द फ्लाइट एंड यू आर नॉट गेटिंग इट, और इन द मीन टाइम आप जो है वो स्टे हो रहे हैं, तो इट्स ओके। ये डेडलाइन अभी तक 31 जुलाई इसलिए है, पहले दिस वाज 31 मई, ये इसलिए है कि उनका ख्याल है कि 31 मई तक सिचुएशन जो है काफ़ी नॉर्मल हो जाएगी। लेकिन अगर सिचुएशन नॉर्मल नहीं होती तो जैसे हम 31 मई से पहले कह रहे थे कि वेरी वेरी लाइकली दे विल एक्सटेंड, तो उन्होंने एक्सटेंड किया 2 महीने। तो अगर अब भी सिचुएशन ऐसी ही रही तो ये 31 जुलाई की डेडलाइन भी एक्सटेंड हो जाएगी। लेकिन ऑब्वियसली कीप वॉचिंग गवर्नमेंट गाइडलाइंस क्या है और उसके मुताबिक जो है वो डिसीजन लिया जाएगा। एक और क्वेश्चन है उर्वशी पटेल, वेलकम। What about people who had applied ILR in November, still Home Office has not responded? कोई भी इंडिविजुअल जो केस है उस पर तो हम जवाब नहीं दे सकते. We are obviously not the representative of that particular case, is that why it's been delayed. But in normal circumstances, Home Office do take around 6 months. So your decision should have been done around in April or May. But because of this pandemic situation, the Home Office is short of staff, so cases have been prolonged. But now Home Office has started working in a better position, so I would advise you to send them a reminder or give them a ring and see what's happening. If you have a lawyer, do chase through your lawyer, and he should be able to shed more lights on this. The question is that, okay, the initial question about 6 months finishes on 29th of July. She has 10 years visa. Okay, that is very tricky. The Home Office has explained or announced that the flexibility they have given is only until 31st of May. So if visa is expiring already on 29th of July, that means they must have come here in February or so. So you will know around 20th of July or so, if not before, that they are extending the time again or not. I believe they may do. So if they extend the time, then you have nothing to worry, but you will need to send them an email, a basic email. But if they are not going to extend, then you will have to leave before 31st of July. So you will only get 2 days extra from 29th. But keep watching the information from the Home Office, or at least continue watching our live sessions, or every week or every 10 days we are trying to do and give you as much as information we can give. So you need to wait until at least 20th of July. So until then you don't have to be worried on that.
Sir, इस पे I would like to take it little further on. तो अभी जो गवर्नमेंट की डिटेल पॉलिसी आएगी लॉकडाउन पे और एयरलाइंस की मैनेजमेंट पे, तो वो जुलाई में आएगी, 4th of July probably. मुझे एग्जैक्ट डेट शायद निकल गई मेरे दिमाग से, लेकिन उस पे देख लें तो probably they will extend the time period. तो वो भी हो सकता है.
It is very likely. There's another question, and this is about extended family member. Again, I always say EA question is my favorite question. Okay, so what about people who applied extended family in Ireland and moved UK but not applied anything here? Then it's your fault. If you have not made an application in UK, that is your fault. You should do it because the deadline is 31st of December 2020. So for an example, you have spent time in Ireland with your sponsor, your British sponsor, I take it, and your British sponsor, under the very present, recent, relevant EEA regulations I'm talking about, if your sponsor has spent at least 3 months or little over in Ireland with you, and he has worked at least for 3 months in Ireland, that is work by employment, that is work by self-employment, any category. So then, and that has to be genuine. So all the genuine documents should be there, and there should be some genuine documents of joint residency. The sponsor has come back and you have come back, you should make an application in the UK. And the test or the requirement that British sponsor has come back and he has started treaty rights here, he has started working here, is no longer required as well. There are so many changes since last July. I know, I remember the time after 2016, the immigration, these EA regulations were changed drastically. Appeal rights were taken away. Extended family member were not allowed to make applications. We fought for it. We went up to Court of Appeal,